Welcome to The Explainer. You know, some words we say every day without even thinking about them. Well, today we're diving into a huge legal battle over just two of those words. Two words you probably know by heart.
So here's the big question at the heart of it all. Does saying "under God" in the Pledge of Allegiance violate a student's rights even if they don't have to say it? I mean, think about that. This question sparked a really fascinating court case that put a modern family's beliefs right up against a patriotic tradition that's over 100 years old. Okay, let's dive in.
All right, so let's set the scene. Our story kicks off in a school district in Massachusetts, and it centers on a family who, for legal reasons, are just called the Does. Now, the Does identify as atheists and humanists, and that's really key to this whole thing.
So the Does had a problem. They argued that the daily recitation of the Pledge of Allegiance in their kids' school was actually discriminatory. And here's the thing, it wasn't about the whole pledge. Their fight was about just two words, "under God." Words that, as you'll see, weren't even in the original version.
So what was their argument exactly? Well, they said the pledge, with those two words, necessarily classifies us as outsiders, defines us as second-class citizens, and even suggests that we are unpatriotic. I mean, that's powerful stuff. They felt it was sending a message to their kids every single day that if you don't believe in God, you're somehow not a good American. You're on the outside looking in.
Okay, so to really get why the court ruled the way it did, you have to understand the backstory. We've got to rewind a bit and look at how those two little words, "under God," ended up in the pledge to begin with.
And here's something that might surprise you. The Pledge of Allegiance we all learned in school? Yeah, that's not the original. The first version was written way back in 1892, and it didn't have "under God" in it. Congress made it official in 1942, still without those words. It wasn't until 1954, right in the thick of the Cold War, that Congress went back and added them in.
So why the change? What was going on in 1954? Well, the reason is actually crystal clear. It was all about the Cold War. Congress wanted to draw a really sharp line between the U.S. and what they called godless communism in the Soviet Union. The whole point was to say, hey, in America, our rights come from God, not from the government. It was a political statement, through and through.
Okay, but there's another really important piece to this puzzle, and it's this. Can a school even force a student to say the pledge at all? It's a huge question, and thankfully, it's one the Supreme Court actually settled a long time ago.
And get this, the court's journey on this is fascinating. In 1940, in a case called Minnersville v. Gobetis, the Supreme Court said, yep, schools can absolutely make students salute the flag. But then, just 3 years later, 3 years, they completely flipped their decision, in the middle of World War II, no less. They did a total 180 in this landmark case called West Virginia versus Barnett.
And the opinion from that case, written by Justice Robert H. Jackson, has this incredible line. He wrote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion." Wow. I mean, what he's saying is that the government has no business telling you what to believe or what to say. The big takeaway? The government can't force you to speak, period. So saying the pledge has to be, without a doubt, voluntary.
All right, so let's circle back to the Doe family in Massachusetts. We've established that nobody can be forced to say the pledge. It's voluntary. But that was the heart of their question. Even if it's optional, is it still a violation of their kids' rights to have this teacher-led, state-sponsored pledge with the words "under God" happening in the classroom every single day?
So, for the Does to win, they had to clear a pretty specific legal hurdle. Their case was based on something called the Massachusetts Equal Rights Amendment. And to make their case, they had to prove that the pledge created a discriminatory classification. In plain English, that means they had to show that the school's policy was treating one group of people, in this case, non-believers, differently from everyone else.
So what did the court decide? Well, in the end, the Massachusetts Supreme Judicial Court ruled against the family. And their logic was actually pretty simple. They said, look, the pledge is voluntary. Every single student has the exact same choice. Say it or don't say it. Since everyone is treated the same, there's no legal classification. They also made a point of saying, hey, there's no proof here that the Doe kids were bullied or treated any differently for sitting it out.
But see, the family's whole argument wasn't really about being treated differently on paper. Their claim was that the pledge itself marginalizes them. It wasn't about a rule, it was about a feeling. The feeling of being singled out, of being made an outsider by a daily ritual that's endorsed by the school and the state, a ritual that goes against everything they believe.
And this is where it gets really interesting. The court basically said, we get it, we understand why you might feel stigmatized, but, and this is a big but, they ruled that feeling, that stigma, wasn't what the law calls a cognizable injury. In other words, just feeling excluded isn't enough to win an equal protection case. You have to show actual concrete harm, like bullying or being kept out of an activity, and the family just didn't have that proof. But wait, the story's not quite over. Even though the Does lost the case, one of the justices wrote a separate opinion that added a really interesting twist, and it kind of leaves the door open for the future.
This was Justice Lenk, and while she agreed with the final outcome that the family should lose, she totally disagreed with why they should lose. She argued, a reference to a supreme being, by its very nature, distinguishes between those who believe and those whose beliefs are otherwise. So in her mind, the phrase under God absolutely 100% creates a classification based on religion. She was breaking from the rest of the court on that.
So you might be asking, if she believed that, why did she vote with the majority? Well, for her, it all came back to that same point. The family just couldn't prove any real harm. Their case failed only because of that. And this is a huge deal. It basically hints that if another family came along with a similar case, but this time they had proof of bullying or being treated differently by a teacher, the outcome could be completely different.
And that's where this whole thing leaves us. It really makes you think, right? In a country with so many different people and beliefs, what does unity even look like? When our most common national symbols mean one thing to one person and something completely different, even hurtful, to another, how do we square that? The court gave its answer in this case, for now. But you can bet this conversation is a long, long way from being over.